Thanks for coming today. Let's talk a bit about how patents are business tools and patent strategies for business and current developments in that area. I am Stephen Glazier. I'm a patent attorney and technology lawyer in Washington, D.C. At the end of this clip, after the Q&A, we will have some contact information, identifying information for your interest. Yes, patents are business tools. We need to focus on that, and in the last decade or so, this has become a matter of increasing interest in the business community. A lot of what we are saying here about patent strategies and patents as business tools applied by analogies to all intellectual property, copyrights, trademarks, trade secrets, and confidential information. The thing to basically keep in mind about patents is that they don't exist in a world by themselves. They are best used as tools to promote success of the business plan of the corporate owner of the patents and to achieve the goals of the business plan. They do this with a variety of strategies which can allow for them to legitimately suppress competition for the patented goods and services and the patented infrastructure, and to allow for the aggressive expansion of market share by suppression of copycat competition of proprietary developments. They can improve operating margins. They can improve operating revenues and growth of revenues, and ultimately this can have an impact on the market evaluation, the market capitalization, the stock price, the value of the enterprise that owns and has developed the intellectual property and is exploiting it. Patents can be monetized. This has developed a great deal of interest in the last few years. We have seen patents used as cash flowing profit centers, which is a new development. They're not merely passive defensive assets. The traditional strategy for most patents is to deter infringement litigation by competitors. We see a much more proactive use of patent portfolios increasingly in corporate America. Patents can be investments and not just overhead items. Patents have obtained liquidity similar to other assets. They can now be bought and sold, rented with much more facility than in the past, which allows patents to go to those owners and users that are best able to exploit them and commercialize them in their business plans, which is good. We also have recent developments in patent metrics, IP metrics that can be applied to the business along with metrics of the associated research and development programs that will facilitate comparative budgeting and benchmarking of performance of IP programs relative to a company's competitors within their industry sector, so that we can have an objective basis to budget and target performance in patent programs, and to rank them compared to competitors, rather than a more traditional seat of the pants sort of budgeting that we have seen. This leads to a quantification of the competitive advantage that may be obtained through intellectual property in the larger product development cycle, which can allow them to be more fine-tuned and provide a quantitative objective basis to present these stories to the management and investment community, both internally and externally. We will have more detailed analysis of many of these points in subsequent programs. Today, this is a very short introduction, so we'll just deal with some of the high points. In older patent strategies, we saw patents applied primarily as a passive deterrent against competitors against infringement litigation. A large patent portfolio offered the threat of a counterclaim to any competitor that sued and tended to deter infringement litigation amongst major legacy players in an industry. There was some licensing, there's some litigation for infringement against competitors. Competitors is basically a defensive, reactive approach, and patents were budgeted as an overhead item. And like many overhead items, they tended to be rationed and limited. Newer patent strategies take a more proactive approach to expand market share in margins, revenue growth, and so forth, as we indicated. There are other developments that we see that we're going into more depth in other programs, including financing by third parties of patent development and acquisitions programs, purchase programs of enforcement litigation and defense of patent infringement litigation, which are of considerable interest. We also have seen an interesting development of some basic rules for inventing on demand, sometimes called the rules of virtual genius. They may assist a development team to pursue patenting an invention, patentable invention, and squeeze the maximum possible advantage out of their knowledge and efforts in this regard, which is always good to do. Some of the items and topics in this presentation have been presented at previous lectures at the business school, at the MIT Sloan School of Management, MIT Sloan School of Management at the Massachusetts Institute of Technology, and at the Georgetown University Business School. And we have borrowed from those lectures, although of course any errors or omissions in the presentation are entirely of the author and not the responsibility of any other party. We're trying to stay strictly to the schedule here. We'll have some Q&A from the audience and go into later presentations and the follow-on segments.